we've got the big prize when we retire, and the question is how much is in that envelope at retirement, and that's what we're going to be talking about. And the topic officially is other non-qualified plans. We covered a couple in Module 1, but we're covering the most common type plans, and it says many other plans could be developed so long as substantial risk of loss and lack of vesting are involved. And I've seen attorneys who come up with these, and even CPAs. Now let's make it simple. It's the Adcock retirement plan. As long as it meets these requirements of a substantial risk of loss and lack of vesting, it's going to work. And we're going to see one of them, especially the Rabbi Trust, which has been very successful. It wasn't named after an individual. It's named after the rabbi who worked for the temple who was getting it. But that's a great example of one that was prepared by attorneys, and you'll find a lot more. And so do not be surprised if you go to attorney or CPA and you see a whole bunch of names of various types of non-qualified plans that you haven't seen in this course, because again, anybody can create a new one and give it any name they want. And reminders to avoid the secular trust covered in Module 1. Likewise, avoid anything with the attributes of the secular trust, which is it's vested or it's a guarantee, anything like that. Even set-aside funding is a bad one, unless, again, you have the special rules, which we'll talk about Rabbi Trust. So let's take a look at some of these plans. Again, these are generic. There's no legal definition of them. They're terms that the Financial Planning Board uses. They're also used by industry. People who sell these plans use these terms, but again, there's no legal description of them as such. This plan with the phantom stock creates a fictional deferred compensation unit account to be used as an accounting entry. And the assigned base value equals the current value of the company's common stock. As dividends are declared, an equivalent credit is made to the account. In many cases, also reflect the stock's appreciation. So what is basically set up is that you don't own the stock, but any dividends declared by the shareholders goes to you, and sometimes even the stock appreciation if it goes up, which is nice if the stock's on exchange. Of course, if the stock is not on exchange, then you come up with how do you value what the stock went up or down. And that becomes an issue, and maybe in your agreement here, which could be a very long document, 50 pages would not be unheard of, you have in there detailed definitions of how you come up with how the value of the stock, market value, would be if there was a market for it. Best used when an employer doesn't want to dilute current ownership and the common stock is on an active exchange. That's the best utopia, but I think you've been around enough to know the utopia doesn't exist very often. Typically it's a case where the owner doesn't want to dilute his ownership and he is not on an exchange, or could be a she owning the company too, and therefore it comes up with this very complicated formula to figure out what the value of the stock should be. And of course you have to be a rocket scientist to figure it out. And yes, I have seen some of these that you either hired some person who is way out in third dimension in math, or someone who probably had too many crackers last night, because some of them are just impossible to figure out. Stock appreciation rights, the SARs, they're similar to the phantom stock, except it gives the right to the monetary equivalent of the increase in the value of the shares of the stock over a specific time period. For example, 5 years and 10 years are very common. It works best for employees who want incentives for employees to remain with the company, and the common stock is on an active exchange. It also does not dilute ownership. And again, it's good. 5 years from now, we'll take a look at it and give it to you, or 10 years. And then it keeps the person with the company, because if you don't stay the 5 or 10 years, you don't get it. It also, if it's not on an exchange, you again have to come up with these complicated formulas as to how to figure out what that market value is. And that's usually the problem with it, if you're not on an exchange. And again, if you're on exchanges, this is overly easy. It's oversimplification for what a company that's big enough to be on exchange would use. So in many respects, phantom stock and SARs are kind of theoretical, although I've seen both of them used, but it's relatively rare. And the next one is restricted stock. This plan has employee stock provided at no cost and is subject to restrictions. Most common restriction of stock is forfeited if the executive performing is subpar or voluntary or involuntarily terminated within a stated period of time and not vested until the end of the period. Can be used by any corporation, retained key personnel. Ownership is diluted, and this is the first one where we dilute the ownership. This has been given, for example, to hire people who are, maybe in mid-career, they're being fairly successful with the company, and meanwhile another company needs that type of capability. Maybe they need it because there was a death of one of the executives, or maybe they've grown to the point they need this particular skill. So they give the person this restricted stock, which again is difficult because you've got to show some objective criteria in the agreement as to what is subpar performance, so we know what it is, or if, and obviously voluntary and involuntary termination is fairly straightforward. And there's a time period called out, and at the end of the time period you get the stock if you met it. I would say that this could result in a lot of litigation because of the, again, two issues. One is what does subpar mean, and the other is the involuntary termination. Did you terminate him just so you wouldn't have to give him the stock? Again, when the stock is finally issued after that 5 or 10 year period, it's taxed as ordinary income, and at that time the owner of the company gets deducted. So it is used. In fact, it's probably used a lot more than it should be because it's a nice carrot. But I've also seen where there's been lawsuits off of it. In fact, in one of the courses I took a few years ago online, spent a lot of time on some of the problems that instructors saw in restricted stock. And again, you have to keep track of this because it is an accounting issue, and you can't hide it within the company. It's going to be, if you're subject to reporting to the Securities Exchange Commission, it's going to have to be on your 10K and 10Qs. And if you have reports prepared for creditors, because you're not subject to the Securities Exchange Commission, they need to know also what this is, because this is going to dilute the value of the stock for everybody else. I would say that, again, this is a common one, probably better than the others, as long as you completely define what you mean by subpar performance. Now, the one I'm most familiar with was where the new sales manager came in. He was a hot shot from the same industry, but for a very large company, and they wanted to make it very attractive for him, so they gave him a lot of stock in that. Restricted probably more than they should have if they would have thought about the ramifications 5 or 10 years from now when he would be a big owner of this company. But they called for him, basically he had to increase the sales by 5% a year, and he didn't make it. One year I remember it was 2% or something, and when he didn't get the stock, in fact he was let go because he wasn't making the sales go. He said the problem wasn't him, it was that he couldn't make the sales because the cost was too high, because the manufacturing was inefficient. And now this guy was a salesman who was very good at knowing the product. He wasn't an engineer, but he had like an engineer's knowledge in the manufacturing area. And he had a whole list of things that were a waste or inefficient, and he was able to, with his lawyer, come up with, if the company would have done this, and they should have done it in the areas, he would have been able to make the sales quota because he could have lowered the price per unit. Now that's kind of subjective, and if it went to court it probably wouldn't work, but it settled out of court because he had a pretty strong case there. And in fact, about the only thing I remember the owner of the company saying, why didn't you tell us about this years ago? Because this 8 years had passed since he came with him. He said, I'm in marketing, that's my job. If I went to manufacturing and to you about a manufacturing problem, you'd say I'm talking out of school. That's right? Okay, IRS Section 83B election. Employee receiving restricted stock we just talked about may elect to recognize the income immediately rather than waiting till there's no longer substantial risk of forfeiture. And of course it's discounted, so it's a lot lower number. The election must be made within 30 days of receiving this restricted stock. And this is very risky because, again, we talked about if you subpar or you get terminated for cause or terminated at will, the employer, quite honestly, you're going to be risky that you're going to make that period of time, the 5 or 10 years, and why taxes now. Where it is useful is very confident in the job security and believe as our tax rates will be higher at the time of vesting. A good example is dad hires his son or his daughter to work in the company, and he gets in the stock because he wants the son or daughter to be able to get the stock now, so that over a period of time he can get this company out of his estate before he dies. And this is very effective for that. And so yes, the son gets the stock, and if he does ABC, which means it's delayed, it makes him also stay with the company rather than going someplace else. Or it might be a daughter that they're doing this with, it might be several children. And then I want to see dad fire his kids, which is not very easy, let's face it. He might fire the son-in-law, so we keep it with the daughters and sons. But it is a very attractive for members of the families. But if it's not members of the family, I'd be very leery to get into something like this because of the subjectivity. You can write up 15 pages of defining subpar, it's still not going to cover everything. And again, if you fight it, you're going to be paying an awful lot of money for lawyers, even if you don't go to court. I don't think very many of these would go to court, if any, but you'll spend a lot of money through arbitration or mediation or just plain negotiations. Junior class shares plan. This plan uses a separate class of common stock where the voting, liquidation, and dividend rights are subordinate to the regular class of common stock. At specific dates or events, it can be transferred to regular shares of stock. This can get very expensive, especially if you're on an exchange. This is a reorganization, in effect, because of the setting up this new stock and having it open. It's usually associated with midterm or long-term performance goals set for the employee. It's taxed when it's vested. So until that comes into being regular class of stock, you have nothing as far as any rights to it. Again, very common. Has different names, and I can't think of any right now, but the same concept of you get the stock as a common stock, but it's not votable, and you can't liquidate it, and there's limited rights on your dividends until such time as some event occurs. In fact, no company who did this. This company was relatively small, software company, had some hotshot people just getting out of college they want to hire, they use this. And then hope that they sold enough shares to the regular members of the ownership that they didn't give too much up to the new ones. My favorite by far, and probably the favorite of most attorneys, and I think people who study different types of qualified plans, this is the favorite for the purpose of the employee, certainly. And from an employer's standpoint, I like it because it's going to set up a very objective way to make sure it's funded, that I'm not stuck 20 years from now coming up with a big bunch of money I didn't plan on. And that happens too often, just like it does in government. So this is probably a fantastic, it came up by a lawyer, not by any government agency. It provides a maximum protection for the employees. A trust is set up to hold the property used for funding a deferred compensation plan. The funds are set aside, are subject to the claims of the employees' general creditors, which means a substantial risk of loss, and thus considered a substantial risk of loss and not vested. Generally, the employee chooses what investments to make with the funds, so the employee, in effect, has this fund, and it will work so when they retire, they have it available, because it's always subject to the claim of the general creditors. Now, what does claims of the employer's general creditors mean? For practical purposes, if the company doesn't go bankrupt, it'll be there. And you say, well, what if the company's bought out? Well, we're going to cover that in a few minutes about how you take care of it so that if the company's bought out and you're under one of these plans. But I would say that without doubt that this is best. The employee knows what money's in there. The company knows it's funded because they are setting aside a fund for it, but it's not vested. Accountants have a little bit of problem doing the paperwork on it, I guess, but generally it's fairly straightforward, and the agreement itself is probably simpler than the ones we talked about so far. In fact, you'll see some Rabbi Trust on the internet, and if it's too good to be true, it's too good to be true. In other words, If it's for free on the internet, it's probably got something wrong with it. And on the ones I looked at, even I, as a more or less lay person in this area, could see fallacies. So, and it's true also if you go to a stationery store that comes up with legal forms. I would just get an attorney. It's well worth it for both the employer and the employee to have attorneys when we're talking about any of these plans. For week 7, the bonus plans, plan in which an employee gets an additional compensation beyond the salary which is taxed at ordinary income tax rates. It allows key employees at the end of a tax year to share the profits generated during the year. Major IRS concern is the lack of employment taxes on bonuses. Thus, reasonableness is an issue, especially for small companies. I've had companies where there's a bonus plan for everybody in the company. I'm sure I didn't work for it, but I know of companies where everybody in the company got a bonus based on performance, and the bonus was typically, we'd figure out the performance. Say we made $5 million more profit than we anticipated. That was in our plan. That $5 million would be split between the company and the employees. So $2.5 million being split with the employees, and it was basically on salary. Although there's some companies who had salary plus years in company would be multiplied years in company by the current salary, and then that comes up with a number, and then they prorate based on that. So there's a lot of flexibility you have on it. You can also have it where it's just a few people get it. For example, you might be a manager above or a key personnel. I had been on one bonus plan where if I had met all of the targets the company sent for me, 1, I could walk on water, and 2, I could have more than doubled my income. And I would say that a lot of times when there are bonuses, first of all, realize that companies who establish bonuses expect people to do very well against, and if you don't, that's a good basis for getting rid of you. A second thing that's probably just important to many of us is that when we are on a bonus plan, our salary might be lower and make you more attracted to getting the bonus and working on it. It's like a carrot and a stick. A third thing, it's got to be based on goals in the future. You cannot be rewarded for past performance. I realize in football and baseball and basketball, last year's performance determines this year's salaries. And that's not true here. We have to have goals at the beginning of the year in order for it to be tax deductible, so that we can measure performance against those goals to make it a valid bonus. Now, some of you may not realize it because the company dummies the numbers for you, but there actually has to be goals, and how you do against the goals is the basis of how much bonus you get. And again, the issue is always going to be, did we take salaries and make it bonuses, which a lot of companies do. They lowball the salaries to make it more of an incentive for people to go for those bonuses, and of course that can raise an issue with the IRS. One of the things that even makes it more frustrating is, how do you compare salaries of company A versus company B, or job A versus B, which again are very subjective in nature. Non-qualified stock options. The employees provided options to buy company stock at a stated price and can be exercised over a stated period. The exercise price is normally 100% of the fair market value on the date the option is granted, but can be set lower. It is ordinary income at the time the option is exercised. Again, offered usually to a select number of people in the company, and is very big when you see the stock options being given at the large companies like I'll just name General Motors, Ford, AIM, etc. Those are typically non-qualified stock options, and so when they exercise it, they have to pay ordinary income tax, which is still a bargain if you think about it, because the stock, if it's going up, now if the stock isn't going up, you don't exercise it, right? We have the incentive stock options, which were really hot items from the 60s to really about 10 years ago. And the laws have been changed drastically, so we're going to reflect the current law. And we really don't have time in this class to talk about the very lucrative prior law, but employees provide an option to buy stocks, the company at the fair market value of the stock at the time the option is granted. Now the maximum is $100,000 per year, and that is a disappointment because, quite honestly, stock options are usually much bigger, which means if it's over $100,000 a year, the amount over the $100,000 has to be non-qualified, the one we covered on the previous slide. The maximum exercise date is up to 10 years from the date the option is granted, and if the shares are held for at least 1 year after the option exercise, and for at least 2 years after the granting of the option, the sale of the stock will result in long-term capital gain treatment. So I have it this year I told Lee, I'm granting you stock options. You wait a year to be able to exercise it. You can exercise a year from now. You hold it one more year after that. It's capital gain treatment. Now, if it's sold before that year is up, before the 2 years are up, based on when I was granted, there's a tax advantage to the company because it's treated as income, and you're taxed at ordinary income tax rate. Where the company does not get a benefit if you hold it for 2 years. So you have to notify the company if you sell it, and they're very insistent on it, so they know exactly what they're doing and how much they really have to tax benefit they can get from it. And it's subject to AMT preferences at time of exercise, and that's why it's gone out of existence for the most part. The AMT is so low today that just adding in a small stock option can throw you an AMT, and AMT is terrible. For those of you who took tax courses or maybe have been subject to AMT, you know how it can drastically increase your taxes, and as a consequence, many people reject the incentive stock options after talking to their tax attorney or their CPA, and go back to getting the non-incentive. In fact, I've had people say, I don't want the incentive stock options. And because again, that AMT preference is a killer. Of course, AMT is not my favorite subject anyhow. Severance pay plans, contractual agreement between employer and employee to make payments after employee's termination. And legal counsel is needed to ensure that the contract is not subject to ERISA rules and is not a constructive receipt at the time of the contract signing. These are, I guess, called silver bullets, golden parachutes, all sorts of names. This is especially important for someone who is under, say, a rabbi trust. So the company be sold to another company, and the company would not recognize that the continuation of the rabbi trust. Or it could be someone who's on any of the other plans here, which the company is sold or during that time period of that waiting for vesting. And so these are quite common. They're also common for executives. In fact, where I've seen it several times is where dad forms a company, he over a period of time sells the stock to his employees, to his children and grandchildren, and then someplace near retirement, he decides to, or his children decide to kick him out of the company because they say, you're too old, Dad, you don't have the modern viewpoint, you're not using your iPod like you should, and they get rid of him. Well, he has, if he's got one of these agreements, the kids can't kick him out. And I've seen that several times where they have this management agreement that says, if you kick me out before I'm 65, kids and grandkids, you're going to pay me a lot of money to get me out. And these are called basically golden parachute plans. That's a general name for them. Some plans are actually platinum parachute plans because they're so large. Most common use is a contract between the employer and employee providing for special severance benefits in the event the corporation changes ownership and the covered employee is terminated. Legal counsel is required since the IRS code has a number of restrictions associated with this plan, and you have to be careful. I would say not only to terminate, but sometimes even if you're not terminated, you can get these payments on a tax favorable basis when and if the company is sold to somebody else, which again, we're always seeing companies bought and sold. Sometimes you never suspect it's going to be gone, and all of a sudden it's part of another company. Well, that's it for this session, and now I guess you got one more week to go, right?